You may proceed.
We settled enough? Good morning, Your Honors. Jill Wheaton, and with me at council table are my colleagues Courtney Kissel and Lori McAllister. We represent the appellant State Farm, and I would like to reserve 5 minutes for rebuttal, please. What happened in this case, and the facts of this case, is what used to be very, very typical. An insurance company was in a dispute with an injured person about the payment of benefits following an accident. They agreed to an amount that would settle their dispute. The injured person signed a release absolving State Farm of liability for all claims related to the accident. Covenant then, and among those was the bills of Covenant Healthcare. Covenant then sued State Farm, and State Farm moved to dismiss. The circuit court held that PIP benefits are not payable to a provider for the benefit of the injured person if the injured person has released their claims. On appeal, the Court of Appeals reversed. Of course, that's why we're here. And it found that a medical bill by a provider constituted notice in writing of a claim of some other person. Therefore, State Farm was aware of Covenant's right. State Farm was therefore required to apply for a court order directing how the benefits should be allocated. And because it hadn't done so, its payment to the injured person didn't discharge its liability. And I emphasize...
Are they believe that we don't know the procedural history?
Well, no, I'm getting there.
Good.
Right now.
Quick.
So the right and required and liability. What? Yeah, thank you, Justice Zara. Thank you.
Right.
But my point is, I'm reading from that because there's 3 important words in there: right, required, and liability, none of which appear in Section 3112, which was the section the Court of Appeals was purporting to interpret. And the no fault earth shook with the issuance of Covenant. And this court should reverse for 4 reasons. Number 1, the No Fault Act does not grant providers a direct claim against insurers for PIP benefits, which was implicit in and underlying the Court of Appeals opinion. Number 2, even if the provider had a claim against an insurer under the Act, such a claim would be derivative of the injured person's claim. And therefore, if the injured person is not eligible for PIP benefits for any reason, including the signing of a release, neither is the provider. Third, for both of these reasons, a request by a provider for payment of bills is not a claim of some other person, and Section 3112 doesn't apply. And in any event, fourth, the 3112 procedure is a process that an insurer may invoke if it wants confirmation from the court about who the proper recipients of survivor benefits are, and it's not a mandatory process that must always be held in order for a settlement to be valid. And this court is starting to see what happens when lower courts find that providers have a right to payment or have claims against insurers. In Hodge, you had to address where such lawsuits can be brought. In the Bronson case, which you've held in abeyance, you have to address whether providers are claimants for purposes of the assigned claims plan. Below, we have chaos. You have Covenant, our case, where the court held that a release and settlement agreement doesn't bar a claim by a provider. But in the Michigan Head and Spine recent case, the Court of Appeals held, well, if the injured person goes to trial and loses, that does bar a claim by a provider. The purpose of the No Fault Act was that an accident didn't automatically result in a lawsuit. And what's happened in recent years is an accident is now resulting in numerous lawsuits. So you wonder, where did a provider's right come from? And you scratch your head, where did it come from? And you read the No Fault Act, and unfortunately after you read the No Fault Act, you scratch your head and you still wonder, where did it come from? Because it isn't in there. And what Covenant has done is they work hard to grab a word from here, a phrase from there, and cripple them together to come up with what they call a clear and independent right, basically a super right, and it has to fail. The Act discusses the rights of injured persons and the obligations of providers. If you look at Section 13107, upon which they rely, it talks about benefits being paid for all reasonable charges incurred for reasonable products, services, etc., for an injured person's care. No reference there to providers. This court held in Belcher that the goal of the Act is to compensate a limited class of persons for economic losses sustained as a result of accidents, and that benefits are payable to injured persons or their surviving dependents. It said nothing about providers. 3157 discusses providers, and 3157 limits the amount that they may charge. 3157 is a limitation to protect the injured person from overcharging, and not, as Covenant would ask this court to hold, a grant of rights to protect providers. 3112, which we'll talk about a lot today, allows insurers to elect to pay benefits in two options. You can either pay the benefits directly to the injured person or for their benefit. It's not two payment obligations, it's two payment choices. What 3112 doesn't say is that benefits are payable to a provider.
Is a charge for services provided an insurance benefit?
Yes? Oh, a charge? No, I'm sorry. No.
I was going to say you lose them.
No, I'm sorry. I will jump to myself. No, a charge is not. Payment of a reasonable charge if it meets the requirements of 3159 and if it meets the requirements of 3107, if it's reasonable, if it was necessary as a result of the accident, payment of that bill is indeed a benefit, but it's a benefit for the injured person.
I'm trying to understand the act, the No-Fault Act, is designed for the benefit of the insureds.
Correct?
They're the ones who are entitled to the insurance benefits.
Correct.
Contractually and under the statute. A provider is contractually entitled to be paid for services because of the contract between the injured, cared for patient and the provider. And so what I'm focusing in on is that in 3112 and other provisions, but primarily there, it's personal protection insurance benefits that are payable to or for the benefit of the injured person. I don't understand how an insurance benefit is transformed into a provider's charge.
Well, I agree with that, Your Honor, and I agree with you that you have to respect the formalities and the legal relationship between the parties. You hit the nail on the head by saying it is the...
Good Lord.
What? It's good.
Well, it happens every now and then.
I know. People tell you that, don't they? The injured person or the insured is the one who has the contract with the insurance company. The provider has the relationship with the injured person. That is the person who's the linchpin in the middle.
But counsel, now I have a question though. And first of all, I enjoyed your summary. I thought that was actually very helpful.
Thank you.
But going to what the Chief's question is, and then going to your responses, is that it specifically says some other person. So help me to understand, why is a healthcare provider not some other person?
Well, what it says, there's two parts that we're looking at. Versus the first sentence where it says that PIP benefits are payable to or for the benefit of an injured person, or in the case of their death, to the benefit of dependents. So in that case, what you're saying is you can pay a provider directly, should you choose so, for the benefit of, not because the provider has a right to, but because it's for the benefit of. And that's a key distinction there, to keep the injured person out of the middle for their convenience, not because you're required to. Later on, though, is this next sentence about the payment by an insurer in good faith of PIP benefits to or for the benefit of one who it believes is entitled discharges.
But isn't it the benefit of, doesn't it really go to the idea that that's the benefit of the healthcare provider? They're the ones who are providing the services, are they not?
They are, but it's the No-Fault Act, not the Guaranteed Payment to Providers Act. And the legislature knew darn well that providers were going to be out there providing services, and if they had wanted to, they could have easily said that personal protection insurance benefits are payable to the providers, the injured person, et cetera. But they didn't, and that's exactly what they're asking this court to do.
Well, the word benefits used 3 times in 3112, 2 in one context and a third time in a different context.
Yep.
But it seems to me that the benefit referred to, where it says for the benefit of the person who it believes is entitled to the benefits, that benefit relates to the benefits referred to in the first line. Would you agree with that?
Yes. Yes.
Well, isn't this a closed system that's created in 3112? It concerns how to make payments for the benefit or on behalf of the injured person who is entitled to the insurance benefits.
Correct.
And if that person, or I guess is the right word, in case of the death of that individual, it's for the benefit of dependents. Those are the only two universe of individuals that are covered by this provision, is not?
Yes.
Well, if you are in a situation where the beneficiary has died, then we're talking about a universe of dependents who may have claims as dependents. I'm trying to understand. Okay, I'm sorry. Go ahead.
No, you keep going, because you're doing a great job.
No, I'm sorry.
No, but you're reading Section 3112, the entirety of it in context, which is exactly what you need to do. And so when you look at that line about payment for the person you believe, in good faith is entitled, unless you've been notified in writing, and then it talks about what will happen, like, well, if there's doubt about the person to receive the benefits, you can apply to the court for an order. And if you don't apply to the court, it goes on.
This is an interpleader action for the dependents, isn't it?
Yes, exactly. Because the only time you would have doubt about the right person to receive a benefit would be who is the proper defendant. Is there two wives coming forward or two kids coming forward? And then it gives you some options. There shouldn't be any doubt when you're talking about a provider. And it talks about allocating a fixed sum. Dependent benefits are a fixed sum. Medical benefits, as we know darn well, are not a fixed sum.
But counsel, isn't
the
the practical implication of this that, I like to kind of keep things simple, but in terms of this case, which is complicated, the real practical implication is that you're really going to turn hospitals against patients, because ultimately what you're asking for
They are against us.
Well, but you're basically going to codify the idea that it's basically your hospital is now going to have to, the only way that the hospital is going to be able to collect is to go after the individual patients. And you pretty much know that individual patients are going to be somewhat judgment-proof. So for all intents and purposes, your goal is to kind of get the insurance companies out of it, which is going to result in having hospitals have to come after patients.
Not necessarily. They could go after patients. They could get an assignment of the claim from the patient.
Was there an assignment here?
What?
Was there an assignment here?
In this case, no. Covenant did not seek one. But you could seek one. In fact, in that case, then there would be no question on the part of the insurance company when resolving the claim. They would have all the defenses available to it that it would have, or at the injured person bringing the claim. And a resolution of that would have some finality to it. So they could sue the injured person. The injured person could then bring in the insurance company. They could get an assignment and sue. Or they could just take whatever they got and move on to the next patient.
Why is it that when you're entering into a settlement with a plaintiff, you're entering into a settlement, why is it that you as the insurance company can't simply indicate when you're entering into that settlement that you want to make sure that all people are paid and that everything is satisfied? Why can't you do that?
That's what we thought we did in this case. It gave a list.
But you specifically left out the healthcare provider.
No, the healthcare providers were included, and they were included by name in the release and settlement agreement.
But to the plaintiff, the whole point here is that the thing that I'm concerned about is that in terms of how this is going to play out in terms of the practice of law, is that if you're able to go to the individual plaintiff, make a deal with the plaintiff, then ultimately, that plaintiff can enter into a deal with you, and the healthcare provider is really left out with nothing after they've provided hundreds of thousands of dollars of services in many situations.
And again,
isn't that kind of the reality of what's going to wind up happening if we were to rule in your favor?
I don't think so. I think what's going to wind up happening is what I just talked to you about the getting assignments. I think some of the frequent flyer litigants, the providers who provide a lot of services at a big high cost and bring massive lawsuits, I think they might go away. I'm okay with that. Otherwise, settlements are going to be the way they used to be, the way they are in other personal injury claims, where you assume that person's attorney is negotiating a lien down with the healthcare providers.
What was the universe before it became recognized in the Court of Appeals that there was a direct cause of action for no-fault benefits by providers?
Yeah, how did they get paid for the first 30 years that the statute was on the books?
Before my time. I assume regular.
Well.
No, I mean, I don't mean to be flippant. I'm just saying I'm assuming the regular way. If, for example, there's a tornado and a tree falls on my house and I have to get a new roof and I go get a roofer and the insurance company gives me the check and I pocket it, the roofer can't turn around and pay and sue the insurance company. He has to sue me because I'm not allowed to pocket and profit from my injury. I have to pay. Why should it be any different when it's a no-fault situation?
Because doesn't this really just allow you to do, and again, I'm just looking at this from kind of how the practice of law is going to go based on how this decision is made. I mean, I guess, Mike, help me to alleviate my concerns. Isn't this just going to allow you to do an end run around the providers, around the hospitals, in a way that's going to really benefit you? It just kind of creates an end run for you.
No, it doesn't. Like I said, it's like anything else. If you are a doctor and you set someone's broken arm because the arm has been broken because I tripped over my own feet, and I don't pay, they're going to have to sue me. Why should it be different? Why should you get a special right because I broke my arm in a car accident? They're asking for this to be kind of a super right.
Isn't that the whole idea of no fault, though? Wasn't that, I mean, in a way, wasn't that, when you look at why no fault was created, isn't it kind of a general compromise? That you're limiting, certain rights in order to protect others? Isn't that kind of the essence of the bargain and the idea behind the Michigan no fault statute?
Yes, but it is meant to protect the injured person so that they aren't left with a whole bunch of medical bills.
Okay.
And when you work together with the injured person to pay the bills, they're not being left out of the equation. So you're not making an end round around the doctor. You are dealing with the person with whom you have the contractual relationship. Just like if the provider isn't paid, he, she, it needs to deal with the person with whom it has the contractual relationship, the person to whom it gave the services. They have no legal relationship with the insurance company.
Is there any problem here that, with respect to at least emergency room providers, they can't refuse service? So under EMTALA, various statutes, they can't refuse service. So it's not maybe quite like the roofer. The roofer could say, hey, I think you might be judgment proof, or your insurance might not be so great. I'm not quite sure you're going to get paid, or if you are going to get paid, you're probably going to go off to Vegas and spend the money and you'll never pay me, so I'm not going to fix your roof. But if you show up at an emergency room, the hospital can't turn you away. Does that affect our thinking at all here?
No, because again, they can bring an action against that person. There's sometimes, in some specific situations, there is an assignment of rights built into the consent to treat.
Oh, so that's interesting. So couldn't this whole problem be solved that way? If the providers just got an assignment of rights from everybody who showed up for treatment, couldn't this problem just go away? I won't treat you unless you assign to me your rights under any insurance that you may have.
It definitely decreases the problem, and when that happens, it helps the insurance companies. Yes, there's still litigation, but at least it is clear that the person is standing in the shoes of the insurer. Because what the covenant's arguing is, we don't even stand in the shoes of the insurer or of the injured person. We're better than them.
Right, I understand.
Equal.
But Kenny, you made a factual claim. You say that this is kind of run-of-the-mill, that ordinarily people get, the providers get an assignment of rights?
So I've been told.
Well, let me, what is the problem here? If I, as you say, if I broke my arm and go to the emergency room and get it repaired, the difference is whether I broke my car in an auto accident covered by no fault versus I fell on my own steam?
Right.
And so the emergency room gets a benefit if I happen to have no fault coverage, and so they don't have to sue me. But
exactly.
If I just broke my arm without it being in an auto accident, the emergency room has to come after me to get their reimbursement.
That's exactly what I'm saying.
So it's entirely a fortuity of how you get your injury.
Right.
Whether you're in a no-fault system or outside the no-fault system.
The No-Fault Act was not meant to make it exciting when an accident victim goes in because the healthcare provider now knows, wow, I have a direct right of action if this person doesn't pay me, as opposed to something else. That's antithetical to the whole goals of the no-fault system, which is to keep costs down.
It's hard for me to understand whether costs are up or down by whether we, by penumbras or emanations, find a right of direct action under 3112 and the other provisions. I don't have any idea what the cost effect of precluding insurers from having these direct actions or not, do you?
Well, I certainly know that the litigation costs would go down, because right now what you have is you have lawsuits in numerous different jurisdictions, numerous different claims. You might be subject to double liability like Covenant was here. I settled with the injured person, but now this provider and this provider and this provider have popped up. And, you know, go to a circuit court or a district court any day of the week, and you are going to see a provider action, a Covenant hearing, and a Covenant hearing. It is a large portion of their docket. It would drastically increase their costs. That's for certain.
If you win this case, you indicated that it's in all likelihood going to result in assignment of rights being routine, which may or may not be the case now. But you said something else. You said the only thing that will happen is that the providers that are bringing a lot of litigation will go away. Help me understand what you mean by that.
Well,
and
there
why
are
that would be so.
There are some providers out there, and again, I don't do the in the trenches work, so I'm just telling you what the trenches guys told me. There are some folks who come along and they do this $1,000 MRI and this $1,000 MRI, this $1,000 MRI, and then they file all sorts of lawsuits. If they have to prove themselves that the claim was warranted, that the charge was reasonable to be subjected to a scrutiny of it, they might not file this litigation as quickly as if they have to go through
But if they have the assignment of right,
Yep.
and they show that they provided the service,
Yep.
why do they have to jump through all these additional hoops? All they have to say is, I've got a right, this patient received this service under the
It
no
was
fault.
reasonable.
Yeah.
Well, that's the question. They have to
Well,
prove that
but
it's
that's the
reasonable.
whole point. If there is an assignment, then it seems to me they are seeking the benefit that the insured would have had.
Yes.
So I think that does make them a proper claimant for personal protection insurance benefits within the meaning of 3112. Then there is, if the patient says, look, you go after the insurance company, then you have a conventional action where the provider said this is the charge, and the insurer can say it doesn't conform to the section that
3157.
regulates the amounts that providers can charge under no fault.
3157.
Yeah.
And if you, as the insurance company, had, for example, a priority argument or some sort of fraud argument or whatever,
But
you could make it.
this is, an assignment is respectful of who is protected
Yes.
and whose interests are paramount under no fault.
Right. It recognizes the legal formalities of the party. It's the insurer who owns the claim, insured who owns the claim, the injured person, he or she assigns it to the provider. That is why the provider can bring suit, not simply because they're a provider, which is what prior Court of Appeals opinions have held and what Covenant is arguing.
So your belief is if there's an assignment, we're basically back where we started, except it would be clear that it's a derivative claim.
I'm not necessarily back where we started, but I like, yes, it's a derivative claim.
Is it a derivative claim?
Well,
no, it's not a
hold on.
derivative
You're going several steps away now. So why are we not back where we started, except that it's a derivative claim? Why are we somewhere else?
Can I just ask, what do you mean when you say back where we started?
Well, sort of in the world that we live in now, where providers will have a right to bring suit because this claim's been assigned to them, and they can bring suit either in the same court or in a different court, and so on and so forth, and we have all this proliferation of all these
16
cases.
lawsuits with one injury. Why aren't we
There's
still
no
going to have
change.
that?
I don't see
Well,
what the
no,
change is.
again, wow. So whether or not the assignment is always valid is going to be a question. Whether, arguably, I think they should be required to sue the injured person, then the injured person brings in the other
Not if
providers.
they assign
Then you're in
the claim.
one court. You're not in
Not if they
1,000
assign
courts,
the
you're in one
claim,
court.
right?
What was that?
If I'm the patient and I assign my claim to my provider, so I'm out of the mix, I don't understand any. I mean, it may result in as many pieces of litigation as are existing now under the Covenant doctrine that there's a direct cause of action for the provider. But so what?
We wouldn't have your lawsuit. Right now, you've got both lawsuits. You have the injured person suing, saying, pay me my medical bills, and the provider saying, pay us their medical bills. If you have an assignment, you won't have that. That person is taken out of the mix.
Let me get something clear. I think this court, and certainly the Court of Appeals, has been imprecise in talking about derivative. If I assign you my claim, your claim isn't derivative.
No, it's not. It's direct. It's subrogated.
Yeah.
I stand in your shoes.
Okay. Anything else?
No, can I sit and?
Can I ask one more question? It occurs to me that if we're thinking about assignment as a panacea, and you go in, you present to the emergency room, and you say, I just had this car accident, and the provider says, I won't treat you unless you assign me your claim, and you say, well, sure, I've got, I'm going to die if you don't treat me, here's my claim. Are you worried that there will be suits about, whether the assignment was made under duress or blah, blah, blah? Is that
Maybe.
something you're worried about?
No. I mean, it
Should
might
we be?
happen, but.
Should we be worried about that?
No, I don't think so. I mean, again, there's not always going to be an assignment. I probably shouldn't have said that. But what I'm saying is there is a way. In response to Justice Bernstein's question, how can providers get paid? Well, that's one way. Suing the injured person and being brought in is another way. So even if the assignment is invalid, you could sue the injured person directly. They could bring in the injured person or the insurance company. There are ways.
So again, it's the hospital versus the patient.
Well, right now, they're kind of phrasing, no, it's not the hospital versus the patient.
It
It's-
isn't?
What?
Isn't that the contractual undertaking of a provider and a patient?
Exactly. I mean,
Why are you scared about that?
well, I don't know, because it sounds bad to say hospital versus patient, but, But right now, they're trying to phrase it that way. They're basically saying, we can do it better, we should leave the injured person out of all this. And no, the injured person is at the heart of all this. You can't leave them out of it.
How does this affect other areas of tort laws? Let's say that there's a threshold injury and there's been an assignment. Can you still then ask for your medical expenses as damages? Or have they been assigned away and now you can only ask for pain and
Or
suffering?
wage loss or whatever? I don't know, probably, possibly. But this court doesn't have to say there has to be an assignment. What I'm saying this court should say is that the Court of Appeals got it wrong. There is no independent right for a provider. And, a settlement with the injured person resolves the claims. And then, there will be fallout no matter what your decision is. But the bottom line is the No-Fault Act does not give providers a direct right of action. There will be a whole industry that comes up to figure out a way to do it. And we'll cross that bridge when we come to
We
it.
have 3 minutes left. Do you want to use them?
No, later. Thanks.
Good afternoon.
Not quite, but.
My name is Dick Hillary.
You wish it was afternoon. So
Good morning. It feels like afternoon. This case isn't scintillating and interesting enough for you, Justice McCormick. My name is Dick Hillary. I represent Covenant Healthcare. Thank you for the time. I do want to say, because I may forget if Justice Bernstein doesn't re-ask the question, but there was a question posed to the appellant's lawyer about doesn't her proposal and her proposed rule, couldn't that result in providers getting kind of cut out of this discussion and left holding the bag? And I want everyone to be perfectly clear here. That's exactly what happened in this case. Covenant was never paid. And so that scenario is not a parade of horribles. That happens when providers are not invited to the table. And so in this very case, a settlement was reached with release language that represented that it included Covenant Healthcare's bill. The money was paid not to Covenant Healthcare as a payee under the No-Fault Act, but to the injured person. And the injured person never paid Covenant. So I just want, this can and does happen. So what I do want to do briefly is simply address the 3 questions that this court proposed in its grant order, give you my answers, and then I'm available to answer any questions. Question number 1, whether a healthcare provider has an independent or derivative claim against a no-fault insurer for no-fault benefits. I share the Chief Justice's comments about derivative and what that means and what the courts have said about that. My answer to that question is this. Under the No-Fault Act, a healthcare provider has an independent claim that is dependent upon the injured person's eligibility to receive benefits. Whether that makes the claim derivative, as this court has defined it in various ways, I don't know. My answer, though, is if it is derivative, it's derivative only to the extent of the injured person's eligibility. In other words, if the injured person is not covered or is ineligible for benefits under the No-Fault Act, the healthcare provider's claim is hollow. It has no right to receive benefits. So the court understands this. I have been in the trenches for the better part of 15 years litigating these cases. In my law firm for 25 or more. Provider lawsuits have been part of our court's jurisprudence for years. They did not just appear on the horizon with Wyoming chiropractic and recent case law. We have been filing these suits when we have not been paid for our medical bills by no-fault insurers for many, many, many years. This is not new. This is not something that's novel. In fact, in 1992, and this is cited at length in CPAN's amicus brief, which was very well done, in 1992, the insurance commissioner, now called OFIS, issued a bulletin that says when there are disputes between healthcare providers and insurers, the injured person needs to be out of that dispute. The payment obligation by the insurer is to the healthcare provider, and that insurance bulletin says very clearly, leave the injured person out of it. Now, I know this court isn't bound by insurance bulletins, but it does give deference to how these agencies interpret laws which regulate them. Question number 2, whether a healthcare provider constitutes some other person under 3112 of the No-Fault Act? Absolutely yes. My answer is an emphatic yes. That answer does not change because the healthcare provider's claim, which is independent, is dependent upon the injured person's eligibility. Some other person says what it says. Our legislature, in my judgment, could not have used broader language to describe this classification or category of payees. Question number 3, the extent to which a 3112 hearing is required. Our answer, a 3112 hearing is never required. It's permitted. It's a procedural mechanism that's permissible that any interested person can initiate if there is doubt about the proper payee to receive benefits. It's neither mandatory in any sense of the word. It is only permissible when there is doubt. Those are my answers.
Okay. And you've used your 5 minutes very well. I am having a framing problem that is, I'm trying to understand your arguments and the Court of Appeals arguments based on the text of the sections that it relied upon to conclude that there was a provider direct claim in no fault. And you heard my questioning of opposing counsel. It appears to me, at least I want to offer you an opportunity to respond to. It looks to me that 3112 creates concerns two classes of individuals. First is the insured who is entitled to PIP insurance benefits, and that those benefits are payable to that individual or on that person's behalf, or in the event of the beneficiary's death, it's his dependents. Everything else, if that's an accurate framing of what this provision covers, is comprehensible, and that the fact that there's a reference to the claim of some other person is entirely contextually related to the fact that if you're dealing with somebody who's dead and they've got decedents who may have claims as decedents, that's what's being talked about here. So I mean, I'm just having difficulty understanding how the fact that a provision dealing with dependent claims and then creates what I think is, in fact, a statutory interpleader for resolving those things, and makes reference to an equitable apportionment, which is something you do with dependents who have multiple claims, but not with providers. Do you think a provider is entitled only to an apportionment of his payment or the entirety?
Oh, I think there could be many circumstances where a circuit court in certain circumstances would make an equitable apportionment to a provider. I'll give you an example. Let's assume
That's
we're-
not the question I asked. Is the provider only entitled to a portion of the charge made? Entitled?
From the insurer, I think a court could entertain a motion and make that kind of an order depending on the circumstances. I think that's possible. I can envision a circumstance where that could occur.
I can understand why an insurer might accept an apportionment, but I don't understand why they're not entitled to more if they meet the other requirements of the No-Fault Act.
Well, I wouldn't disagree with that, but I could certainly understand if there was, I mean.
I really point out that apportionment is an odd concept when you're claiming there is a direct entitlement of a provider to make a claim, and particularly when it's in the context of a provision for making persons who are entitled to insurance benefits.
I don't find it odd.
Okay, well, let me ask you this. Is your client's bill for services rendered to the insured an insurance benefit? Or is it a
I'm not,
claim
and I
for
heard,
payment?
and I'm not sure I understand that question.
I'll rephrase it for
Thank you.
Is a claim for payment an insurance benefit?
A claim is the claim itself.
I'm Dr. Young. I have provided $30 of medical services to you. Now, I want payment. Is my bill for $30 an insurance benefit?
You've overcharged, first of all.
I'm a very good doctor. By proxy.
I think the answer is yes.
And why would that be?
The services and the bill and they are all the same.
A bill is an insurance benefit. Not a charge.
Well, of course not. The paper bill is not an insurance benefit.
I'm not trying to be coy here. What I've got is a charge, but not an insurance benefit. I'm hoping to recover my charge from insurance benefits, am I not?
The services have been provided.
I agree. I got the bill. I've sent you the bill. Is that bill for service, are the services themselves an insurance benefit? I think they're clearly not, right?
I think they are under the No-Fault Act.
Why?
In my judgment, when a medical provider provides reasonably necessary services, accommodations, and products, those are benefits. Those are benefits that
insurance benefits?
I take the position that they are. They are.
Okay,
They are.
I understand, at least I understand your position. Okay.
And so, but I do need to quarrel with you somewhat on. Well, more deeply on your reading of 3112 of the No-Fault Act. And I believe, with all respect to the court, you're misreading the very first sentence, which says, personal protection insurance benefits are payable to or for the benefit of the injured person.
Correct.
So we know that they're paid to the injured person in certain circumstances. We also know that they are paid for the benefit of the injured person.
Yeah.
This is
paid. But benefits are being paid is not the same thing as bills for services that are payable from the benefits. That's the question I'm asking.
And I believe, and I disagree with you, that they are. But I need to finish my thought here, because I think you said to me that you read 3112 as dealing only in circumstances where you have benefits payable directly to the injured person, or in the case of his death, to his dependents or survivors.
Payable to or for on the benefit.
Well,
for the benefit of the insured.
So the very first clause of 3112 says personal insurance benefits are payable to or for the benefit of the injured person, or in the case of his death. So if benefits are payable when there's not a death, for the benefit of the injured person, who is that? I ask rhetorically, and I answer to you, it is service providers. You cannot read it any other way.
I don't read it any other way.
And
But
so,
those are benefits payable, they're not bills.
if they are benefits payable to a service provider under 3112, which is the statute that provides persons to whom personal protection insurance benefits are payable, and they're not paid to the service provider has a right, as every single Court of Appeals panel has decided, to bring a direct claim to see that right is obtained. No question about it. That is what 3112 says.
Okay.
Why does the rest of 3112 talk about an entirely different subject then?
I would say that it doesn't. The very first sentence we've just talked about and described. The second sentence discusses when and under what circumstances a good faith payment by an insurer can be made and result in a discharge of that insurer's liability to the extent of the payment. The third sentence discusses doubt and the circumstances when doubt may arise and when a 3112 hearing may be permitted. It's the very last section that simply talks about, in the absence of a court order, an insurer may pay in a death case as follows.
So did the legislature make a mistake by putting that provision there? Should they have put that in a different section?
I am not, I don't know why it's there, but I don't think it's the fact that it's at the end of 3112 describing what can happen in the absence of a court order in the case of a death case limits in any way the remaining effect of 3112 and my right to a direct action.
Mr. Hillary, the first section of that first sentence before the or, which I appreciate your rhetorical question and answer, does say benefits are payable to the injured person or for the benefit of an injured person. So we have to figure out what for the benefit of an injured person means there before the or. But why isn't it possible that it means what State Farm says, which is just if it benefits the injured person to have the payment go directly to the provider, then that's a choice that the injured person could make. I mean, I like it when my insurance company leaves me out of my health care billing. I hate it when even my, when the doctor's like, should we, I'm like, oh God, please, no, leave me out of it. Like, it would be for my benefit to be left out of it. Why isn't that just one way to think about it?
And for practical purposes, that's what happens.
Right.
That's what always happens.
Why is that? So then why should we read that to therefore create this right for the providers to sue directly? Why isn't it just, sometimes it's in the benefit of the injured person who the whole act protects to get out of the middle of this arrangement?
Well, for practical purposes, you're right, Justice McCormick. Hospitals bill insurance companies in a no-fault case like in any other case, and the payments are made directly to the hospital or the physician.
And that benefits me.
Right.
But that does not in any way, when that doesn't happen,
Yes.
and they're not paid, the question then becomes, what does a hospital do? What is its remedy? Where does it go? And my answer to that question, Justice McCormick, is it looks to 3112 and says benefits are payable to the injured person or for the injured person's benefit. When that doesn't happen, there's a judiciable interest on the part of the provider standing a direct action to see that that happens.
See, that's a non-textual issue. I'm trying to figure out where I can deduce from the language of this section. This is really, I mean, I know some courts have cited the reasonable payment. I can't even understand why that's in play.
I can explain it to you.
Well, okay, but let me ask this question. I'd like to understand that. But here, the fact that either the insured doesn't ask for the direct payment to his providers, or that just doesn't happen, doesn't seem to me to create this, you say a justiciable interest. That's like an emanation or a penumbra, isn't it?
That was and I apologize for using that language.
Okay, accepted.
And I don't mean to minimize and place my direct right of action into this penumbra that you just described.
That's what I'm looking for.
So
tell me textually how I deduce that the fact that this provision allows for the direct payment when they are to a provider, when they are for the benefit of the insured person, causes then a direct right of action for the insured to directly seek those benefits.
And you've lost me.
Okay.
Tell
me why the other provision then is.
Well, and we've briefed this, and it's really set forth in every Court of Appeals opinion back since Lakeland NeuroCare, and as recent as Judge Talbot's decision in Wyoming Chiropractic.
3157 textually requires a direct payment.
3107 provides that personal protection insurance benefits are payable for the following: allowable expenses consisting of all reasonable charges for reasonably necessary products and services and accommodations. 3157.
Wait a minute. Okay, but before you move on, those are what are permitted expenses, right?
Those are what an insurance company is obligated to pay.
No. They are what charges are permitted, right? It says that a person or institution providing services may charge a reasonable amount for the services and accommodations rendered, and they shall not exceed the amounts.
Okay, I was looking at 3107.
Okay, all right.
You're on 3157.
Okay, I'll look at 3107. Go ahead.
3107 says PIP benefits are payable for the following: allowable expenses for all reasonable charges, necessary products, services, and accommodations.
Okay.
3157.
Wait a minute, before you move on, tell me why that causes, that creates independent cause of action, because those are payable expenses under no fault.
Because then you go to 3157.
Okay.
Which addresses specifically what physicians, hospitals, service providers lawfully rendering treatment can do, and what they have a right to do. A physician, hospital, clinic, or person or institution lawfully rendering treatment to an injured person for an accidental bodily injury covered by PIP and may charge. It's a right. We may charge.
You may charge it, but that doesn't give you an independent cause of action, does it?
If we can charge it and it's payable and it's not, then we have a right. There's nothing in the statute that says we don't.
We have to imply that right, though, don't we?
You go straight to 3112 in the very first sentence, which says benefits are payable for the benefit of the injured person, and when they're not, we have a direct action consistent with the No Fault Act, its principles, ensuring prompt payment, removing injured persons from these disputes. The suggestion that our remedy is to simply sue the injured person, and that will solve this proliferation of lawsuit problem.
Are you saying there's been no I can't say the word now. Proliferation of lawsuits?
And I'm not saying there is.
You're not saying there isn't, are you?
I'm not saying there is a proliferation. I'm not saying there isn't. What I'm saying is... Pardon me?
What about the assignment issue? I finally got the word out.
Okay, the assignment...
Yeah, right.
So that's interesting, because it's been suggested that could be the panacea to solve this problem.
It would give your clients a cause of action if they had an assignment. That's what
Well, what I would say to the court is we don't need an assignment because we already have a direct action. So that's my answer to that question. But here's where we are. Section 3143 of the No Fault Act prohibits and makes void and unenforceable the assignment of a right to future benefits.
Okay.
Now, I'm going to give you a little bit of background, and you may tell me you don't want to hear it.
Can I ask you
because
a threshold question?
Yes.
Why do we care whether providers are inconvenienced by if it's accurately construed, there is no direct right of action under these provisions? Why is this court entitled to care about what the repercussions of that are for providers?
You shouldn't. It's a matter of public policy.
As a matter
That would be
of
for the legislature. I'm not suggesting to the court that is something the court should you care? Yes, but are you empowered to resolve that?
Are we authorized to care about the
No, and I'm not suggesting you are, because I have a direct right of action under 3112. I'm not saying that the assignment is my panacea. And I think that right's far more clear than anyone else apparently does, but it is there.
I just get to ask the question.
Yeah, so 3143 prohibits the assignment of future benefits, makes those assignments unenforceable. So coming into the emergency room, Justice Larson, this was your question. Why not just get an assignment? Well, that would be an assignment of the right to receive future benefits. No service has been provided. That assignment at the front end would be unenforceable. So now you're requiring service providers at the back end to get these assignments. It's very difficult as a practical matter, and I say this because I am in the trenches, and I do understand this, and I understand the Chief Justice may not care, but
the question I asked you is, what authority does this court have a right to be concerned if we accurately construe this statute and it results in the loss of the covenant theory of direct action? Why are we privileged or authorized to be concerned about what the repercussions to providers are? That's my question.
Oh, and I thought I answered it.
Yeah, I did.
You
said I didn't care.
You're not. I thought you said, why should we care? And maybe I misunderstood the initial question.
It was inartful.
But Justice Larson, and this was your dialogue with Appellant. There are practical problems with getting these assignments at the back end even. Very often patients are incapacitated, they die, they're homeless, they're non-cooperative.
But counsel, there is no difference in the challenge to a provider between the person who comes in with the same injury, in one case because of an auto accident, in another case just an accident. The challenge to the provider of providing the services doesn't depend on whether, and recovering.
Well, in fairness, I don't disagree with that, but what I will say is the Michigan No-Fault Act is not like any other health insurance policy. It's not like it is a comprehensive act, remedially construed to make sure that benefits are promptly provided for the lifetime of an injured person.
For the benefit of the beneficiary.
To or for the benefit of the injured person, which
not
would
the
include
benefit of a provider.
To or for the benefit of an injured person, and that includes a service provider who has provided services compensable under the No-Fault Act. So
wait,
this
the provider is an injured person?
No, I didn't say that.
Oh, okay.
To or for the benefit of an injured person.
Okay.
And for the benefit of the injured person, as we've talked about, I believe gives me a direct action if that statutory obligation isn't met. But I need to say this because I know Justice Viviano, in the Bronson case, which you held in abeyance on the MACP, you had mentioned, does MVARA have anything to say about this? And I know this court has said model acts are not something that this court looks at, but you asked, it was on your mind then, so I need to say so. MVARA, the model act on which our No-Fault Act was based, also prohibits and makes void and unenforceable the assignment of future benefits.
What does it say about direct provider lawsuits?
It then says, MVARA then says direct payment to providers is authorized and allowed, and
That's what this provision
and carves out front end assignments and says the assignment of future benefits are unenforceable in MVARA unless it's a service provider. Unless it's a service provider, then those assignments are enforceable. The Michigan No-Fault Act dropped that and then added 3112. And there is no counterpart in MVARA to 3112. And so my position is,
Okay, doesn't that mean the legislature looked even more askance at direct provider lawsuits?
and concluded that they are viable and authorized through 3112 because they dropped the assignment language that was authorized in MVARA from our No-Fault Act and placed 3112 in and have given us a direct action.
Okay, interesting.
Anything else?
No.
Thank you.
Thanks.
Okay. Just a couple of points in rebuttal. There was lots of hammering nails on the head over there, so you were right, Justice McCormick. Just
Don't say that
allowing.
out loud.
What? No, you're next. You're next. You were right, Justice McCormick. Just because you are entitled to give the courtesy and give the benefit to the no fault the policyholder by going directly through doesn't mean that automatically creates a right in the provider. You were right, Justice Young, that 3157, 3107 say nothing about a right of action.
I just have to ask, because again, I like to keep things
Was he
simple.
right?
Well, no, I don't.
Yes, when he liked my presentation. I was very right about that.
It all goes downhill from here. Let's focus on for the benefit.
Yep.
And, and again, I like to keep it simple, and then I have some questions to ask you after this one. But when you talk about for the benefit of the injured person, when the legislature crafted that, they said for the benefit. Is it not for the benefit of the injured person that the hospital has a direct claim against the insurance company rather than having a claim against them? Isn't it for my benefit? If I'm in a catastrophic injury and I'm in the hospital, isn't it for the benefit of me at that point that the hospital can go to the insurance company rather than the hospital coming after me for millions of dollars? Isn't it for my benefit that you can have that direct action against the insurance company? Or the hospital can have a direct claim against the insurance company? Is it for my benefit that way? How is it not for my benefit that way?
No, it's definitely for your benefit.
Well, that's
but
the
you
words, right? It says for the benefit of the injured person, right?
It says benefits are payable too. It doesn't say that there's a cause of action of providers.
For the benefit. Does this not benefit the injured person? Isn't that what the legislature was really trying to get to? Why would you put that language in if you're not going to try to benefit the person who you're trying to help, right?
Correct. But again, to me, that doesn't give a direct right. You still have an obligation as an injured person, as an insured, to participate in your care, to work with your insurance company, to assist them, et cetera. Justice Viviano, you got it right when you were talking about the fact that you need to read this section in context 31 as an entirety. So
Those
the
stats are
quote-unquote...
easy to come by today.
What? The quote-unquote clear, direct, and independent right of action as set forth by Counsel for Covenant was, well, you look at 3107, and then you look at 3157, and then you look at one sentence of 3112 and ignore the rest. And that is my clear, so obvious
I'm
right.
not kind of done yet. For my direct, here's the
come on.
But Counsel, you still haven't gone back. If they have the direct right, it's for my benefit, right?
Yes, but that alone doesn't give right to it. There's all sorts of things that would benefit
Why would they
people.
use that language? I'm just doing a plain meaning of the statute. Why would they use that kind of language for my benefit? It's for my benefit that he has a direct right.
Because of what Justice Young was saying before. It all comes down to the fact that the benefits belong to the injured person. What can we do in this act that will help the injured person, the insured? Well, we can make it so that the provider can be paid directly.
But doesn't it help the injured person that I have a strong hospital system that's able to provide care for them? Doesn't that help the injured person if the hospital system is able to do this without creating a situation where the hospitals are going to lose millions and millions and millions of dollars?
I don't think they'll lose millions and millions and millions of dollars. They'll be like hospital systems in most other states where there aren't direct right of action. And I don't think it's up to this court to think that this decision is going to either make or break the entire hospital system in the state of Michigan.
Well, the amicus briefs were pretty powerful. I mean, we had amicus briefs going kind of back and forth on that. So then do you not agree with the amicus brief that was submitted by the city of Detroit and the other amicus briefs that were in your favor?
I agree with those, absolutely, positively. Well, that's your question.
All right, thank you very much. The case is submitted.
Thank you.
Perkovic versus Zurich.